Hey everybody, this is Tracy here with another edition of A View from Tracy's Point, and we are here with the latest update on the Eastern District of New York versus Robert Sylvester Kelly. So yesterday, it was yesterday, in response to one of the motions by Jennifer Bungine where she talked about, I believe it was ineffective counsel and Mr. Kelly's attorneys allowing jurors to sit that had seen surviving R. Kelly or had extensive knowledge of allegations against him, allowing them to be seated on the jury. Well, yesterday there was a scheduling order from Judge Donnelly where she is requesting that the government provide to her no later than April 20th the jury questionnaires completed by the prospective jurors who were ultimately selected as jurors, as well as those who were questioned and excused, and that's due by April 20th. And then it was ordered by Judge Donnelly on yesterday, and that is under seal. So once they supply that to her or submit that to her, we won't be able to see the questionnaires or what the people wrote on the questionnaires. And I'm not sure if she's leaning towards saying, yeah, there was an issue with juror selection, or if she's requesting these documents so that she could write her finding to say that, oh no, there wasn't an issue because of this, this, and this. So it will be interesting to see how she uses this information that she is requesting. And then on another note, today, which we're not surprised because she had already, before even allowing Jennifer Bungine to respond to the prosecutors about the motion for reconsideration, Judge Donnelly already denied it and said, but I will push it out a few weeks to June 16th, and that's for the sentencing. Now she's writing her formal reason for why she denied the request. And as usual, for those of you who are new to this channel and wondering what the heck am I talking about, this is coverage of the case of the Eastern District of New York against Robert Sylvester Kelly, also known as R. Kelly, the king of R&B, one of the greatest writers and producers of all time. And if you've been under a rock, then you may not know that in September of last year, he was found guilty by a very tainted jury on, I believe it was 9 counts of racketeering and the Mann Act. And now he is in the post-trial phase where his attorney, Jennifer Bungine, is trying to either get his conviction overturned or to get a new trial. And this is the first step to actually going to the Second Circuit of Appeals Court to have them review the case. I'm not sure she has much hope that Judge Donnelly, who has shown bias throughout the case, is actually going to rule in her favor on anything, but she does have to set the groundwork. And before I get into Judge Donnelly's response that was filed today, some of you have been asking me or talking about, information, being sent to Jennifer Bungine, sort of like Ariel Clary, things that Ariel is saying in interviews or things that she said on her social media or stuff that has come out, about the parents and that type of thing. And so I want you guys to know that any new information, it has to be new information. It can't be information that's already in the 3500 material. But if new information comes out that is so compelling that it would have changed the course of the trial and possibly change the jury's verdict, that has to be submitted to Judge Donnelly. They can't hold on to any new information and then present it to the appeals court. The appeals court only looks at the case prior to it being sent to them. They won't look at new information. They won't look at new statements or contradicting statements. I haven't watched the interview with Ariel where she was on Hollywood Unlocked with Jason Lee. I know several people had asked me to give an opinion on it, but I haven't watched that interview yet. Or something else, the Toxic Diamond interview with the Kevin Sullivan guy. I've only seen bits and pieces of it, but I'll try to make time to watch both of those videos and then come back and do a response to it. But anything that Ariel said, like people are saying that in the Jason Lee interview, Ariel stated that nothing happened between her and R. Kelly prior to her turning 18. So yes, Jennifer Bonjean can look at that and then she can turn that in or write a motion and submit it to Judge Donnelly, to kind of impeach Ariel or to get it on the record for when she goes to the Second Circuit. But she can't take that information to the Second Circuit and say, hey, this new evidence has come about and I want you to hear it and rule on it. It doesn't work that way. Any new evidence has to be compelling and could really make a difference in the outcome of the trial, and it has to be submitted to the judge over this case currently, which is Ann Donnelly. And then if Ann Donnelly says, well, I don't think it's compelling or it would have made a difference, then when it goes to the appeals court to have the whole thing appealed, then it's already part of the record and the Second Circuit of Appeal can review it at that point. Now, that's my understanding, and I always give you guys this disclaimer that when I went to college, I did not get a degree in law. Okay, so I'm just interpreting this as I'm understanding it and as I'm reading up on, judicial law and that type of stuff, that once you go to the appeals court simply looks at the case and whatever issues you're raising and concerns as to why they should rule in your favor. They are not there to hear new evidence that may have came about or evidence that wasn't entered during trial that may have been overlooked. Because we all know that there's a whole bunch of stuff that could have came up in trial. We don't know if it was in the 3500 material. Some of it we know was in motions that were filed by Thomas Farinella, but Judge Donnelly, ignored it, overlooked it. We know that there were things when it came to the bad acts witnesses that Judge Donnelly made rulings which basically prohibited the defense from questioning certain aspects of the stories that the bad act witnesses, were going to tell. She refused to. She said that there would be no hearsay testimony, but then she allowed people to come and tell stories that they claimed that they saw firsthand, like Javante Cunningham talking about the whole R. Kelly and Aaliyah in the back of the bus, when there was zero proof that actually happened. But because Javante was saying that she eyewitnessed it, she saw this herself, she allowed it. And so that type of stuff they can bring up to the appellate court, the rulings that Judge Donnelly made on certain evidence, but they can't bring in new evidence. So I hope that makes sense to you guys. Now let's go ahead and get into this motion, that the actual final written response from Judge Donnelly. And so it's her denial for delay. And get y'all know how I be, my computer be getting stuck when I'm trying to scroll through this stuff. And so it says on April 5th, 2022, I granted in part and denied in part the defendant's motion to continue sentencing. Specifically, I denied the application to adjourn sentencing until after the completion of the defendant's trial in the United States District Court for the Northern District of Illinois, but granted an adjournment until June 16, 2022. The defendant now moves for consideration of that order. The government opposes for the reasons discussed below. The defendant's motion is denied. Standard of review. Although the federal rules of criminal procedure do not provide for reconsideration motions, such motions are technically accepted in criminal cases in this district by virtue of Local Criminal Rule 49I Section D, which requires a movant to submit a memorandum setting forth concisely the matters or controlling decisions which counsel believes the court has overlooked within 14 days after the court's determination of the original motion. United States versus Baldero, and that was heard in the Southern District of New York, January 20th, 2015. And then there's a note at the bottom of the page that says the court ruled on the defendant's motion before counsel had the chance to reply to the government's opposition. This was an oversight. So I guess she's trying to low-key apologize to Jennifer Bongine for, being biased and putting out her response without allowing Ms. Bongine to respond to the opposition. So courts generally supplement Local Criminal Rule 49 ID with the standard for civil reconsideration motions under Local Civil Rule 6.3, and then citing United States versus Lever, United States versus James, and let's see, those were cases that were heard in the Southern District of New York in 2005 and the Eastern District of New York in 2007. And it's quoted as saying, when deciding motions for reconsideration in criminal matters, courts in this division have resolved such motions according to the same principles that apply in the civil context. Internal quotation marks and alterations omitted. Local Civil Rule 6.3 requires the moving party to identify, quote, the matters of controlling decisions which counsel believes the court has overlooked, end quote. A motion for consideration, and then they have quotations, is not a vehicle of relitigating old issues, presenting the case under new theories, securing a rehearing on the merits, or otherwise taking a second bite at the apple. Analytical Surveys Incorporated versus Tunga Partners, which was a case heard in the Second Circuit in 2012. Internal quotation marks omitted. And then from that case, and that was from what I was just reading, and then from a case, United States versus Robinson in the Eastern District of New York from November 13, 2018, she is citing, rather, the standard for granting a motion for reconsideration is strict and consideration would generally be denied unless the moving party can point to controlling decisions or data that the court overlooked, matters, in other words, that might reasonably be expected to alter the conclusion reached by the court. Discussion. In seeking reconsideration, the defendant does not identify any matters or controlling decisions that the court overlooked in denying his motion for an adjournment of sentencing until after the trial of his case in the Northern District of Illinois, which is currently scheduled for August 2022. Rather, he repeats the argument he made in his initial motion. Accordingly, reconsideration is not warranted. In any event, the defendant's arguments are not persuasive. Federal Rule of Criminal Procedure 32B1 requires the court to impose sentence without unnecessary delay. Moreover, the Crime Victims' Rights Act provides that the defendant's victims have the right to proceedings free from unreasonable delay, and that's from United States Code 18, Section 3771A7. In this case, the jury returned its verdict on September 27, 2021. The practical effect of granting the defendant's request would mean the sentencing would take place about a year after the jury's verdict. In seeking an adjournment, the defendant maintains that proceeding to sentencing in this case before the completion of his upcoming Illinois trial forces him to choose between speaking with a defense mitigation specialist and invoking his Fifth Amendment privilege against self-incrimination. He claims that he cannot speak openly and candidly to a mitigation expert as another massive federal prosecution looms. The defendant's concerns do not justify the significant delay in sentencing that his request entails. The Fifth Amendment protects against compelled self-incrimination. Ohio Adult Parole Authority versus Woodard, a case that was heard in 1998. And then they cite another case, United States versus Greer, from the Second Circuit in 2011, which states to qualify for Fifth Amendment protection, a communication must be 1, testimonial, 2, incriminating, and 3, compelled. And then from another case, they put statements to a mitigation expert are not compelled for purposes of the Fifth Amendment because the defendant can choose whether to speak to the expert at all, as well as what to tell the expert. Even after the report is completed, the defendant can make the choice not to submit it to the court. The defendant's feelings of pressure to speak to a mitigation expert in hope of improving his chance of receiving a more lenient sentence do not make the interview compelled. And then she has a note at the bottom conceding his sentencing hearing cannot be postponed indefinitely. The defendant does not seek to adjourn sentencing until after his pending state criminal trials. And I think that was where the government was trying to say that even if they did a delay until after the Northern District of Illinois, there's still the Cook County case and still the Minneapolis case, and that if the judge granted the delay until after the Northern District of Illinois case, then they were going to come back and say, well, we need another delay because of the Cook County case and another delay because of the Minneapolis case. And to be honest with you guys, I can understand where the prosecution is coming from in that. And I probably wouldn't make such a big deal of it because we already know how biased Judge Donnelly is. And so this is going to end up at the appeals court, the Second Circuit of Appeals Court, and possibly all the way to the Supreme Court. And then let me put a pin here, because I was thinking the new woman that was appointed to the Supreme Court, the Ketanji Jackson, what was that woman's name? Ketanji Jackson Brown, I think her name is. I was reading a little bit about her, and one of the things that the Republicans was like throwing up in her face during her confirmation hearings is that she was very lenient on people that were charged with CP, child pornography, that she was very lenient. And I was thinking to myself, well, if this case goes to the Supreme Court, she probably will be the swing vote, because she might be like, this man don't deserve life in prison behind this BS that y'all done brought before us. So I'm not going to give too much credence to Judge Donnelly refusing to delay sentencing, because we already know that there's a 99.9% chance that this is going to end up hopefully going before the appeals court. And hopefully, because I have to remind you guys that there's no guarantee that the appeals court will hear the case, but hopefully they will see that the acts on behalf of the prosecution were so egregious that this case needs to be heard by them. And because they're trying to use this case as precedents in other cases, hopefully they will be willing to hear the case on those reasons alone. So let's go ahead, and I can't tell if this is another part of the note. Yeah, I think this is a continuation of this note. So let me start back over at the beginning of the note. So it says, conceding his sentencing hearing cannot be postponed indefinitely. The defendant does not seek to adjourn sentencing until after his pending state criminal trials. And then she has holding the Ohio clemency interview process, during which the respondent had the choice of providing information to the parole authority at the risk of damaging his case for clemency for post-conviction relief, or of remaining silent, did not violate the Fifth Amendment privilege against self-incrimination. Oregon versus Elstead, which was a case heard in 1985. And then in a case, United States versus Davis, which is heard in the Southern District of New York in 1989, it says, holding that officials' failure to administer Miranda warnings creates a presumption of compulsion for Fifth Amendment purposes. Indeed, defendants who wish to challenge their guilt on appeal, as the defendant apparently plans to do if this post-trial motions are denied, face a similar choice. And then denying the defendant's request to limit use of his statements in connection with his sentencing to protect his Fifth Amendment privilege and his right to a meaningful appeal, because there is no basis for the court to insinuate or insulate him from the consequences of his statements. And that was basically verbiage that was used in the prosecution's response, saying that the request to delay sentencing should be denied. And so she's just notating what they wrote. And then basically that's it. Her conclusion was that accordingly the defendant's motion for reconsideration is denied. And this basically is what she would have said had she not jumped the gun and put out her decision that she was going to deny delaying to the end of the Northern District of Illinois case. But she was extending it to June 16. This is what she was going to write anyway. So regardless of Jennifer Bongine responding to her saying, you didn't even give me an opportunity to respond to the government, she had already made her decision. And so she's just putting in writing why she made her decision. And so nothing has changed. And then I forgot to say at the beginning that to the people that are new to my channel, you can go back. I have a playlist called the R. Kelly series where you can, if you want to learn more about the case, most of the videos are there. But at some point I had to stop putting his name in the title. We don't know how YouTube picks up when they are going to deny monetization on a video. And so I tried things like not putting the videos in the playlist. I tried not putting his name in the title. I tried not entering keywords that had his name in it, that type of thing. But if you go to my community page, there is a list of all of my videos, and I can tell you for the past 2 years. So I did the R. Kelly series playlist, which should include all of the videos up until about a year and a half ago. But then if you go into all of the videos on the community tab, click videos, and then you can just scroll down and all of my videos are there, and you can click on the ones, and they're pretty much titled what the video is about, whether it is the reading of the transcripts from the trial, if it was a news story, if it's motions that were filed in the case. The titles are pretty self-explanatory, and you can get caught up on the information that way. So guys, that's it for me. I am going to go ahead and leave this here. Leave your comments below, rate the video, and subscribe to the channel if you haven't done so already. And until the next time, I shall talk to you guys later. Bye-bye.